Thank you very much, Jonathan, and good morning to everybody from me as well. So let's talk about Brexit. So as Deputy Commissioner responsible for policy at the ICO, that role includes overseeing the ICO's international functions and including since 2016 our planning for the world in looking at what happens with Brexit. I had hair back then. By way of introduction as well, I want to say that today's panel will be resolutely practical. So we're going to be focused on planning and preparing for the data protection implications of Brexit. So we're not going to be speculating on political developments or what the government may or may not do next. We're going to be focused on organisations. So in both the public and the private sector, and what organisations should be doing or what they are doing now to prepare for that world in terms of exiting the EU. So there's no Laura Kuenssberg or Katja Adler on this panel today. So I'd like to firstly introduce our panel to you. So to my left, needs no introduction, your Data Protection Officer of the Year, Mikko Niva, Group Privacy Officer from the Vodafone Group. So Mikko will particularly bring that perspective of a major telecoms company and the different data flows they have to handle around the world, and particularly from the UK to the EU and vice versa. Then directly to my right, I have Roxanne Morison, who's Head of Digital Policy at the CBI. So this includes an important role in leading policy development and lobbying in UK and Brussels, including on data protection. So Roxanne will bring that wider, broader perspective of the UK business community. Then lastly, on the end at the right, we have Eleonor, who's a lawyer at Fieldfisher Waterhouse, based in London. I know Eleanor very well. We spent many nights in darkened rooms in Brussels in negotiations for the GDPR when she was a government lawyer in that period of negotiations from 2012 to 2016. She also comes from extensive experience of working in DEXU in government as well. So she comes from the perspective now of advising private and public sector clients on the implications of Brexit. And she also comes from that perspective of seeing it from inside government as well. So I'm sure you'll agree that we have a really well-qualified panel to give you some different insights and perspectives on the data protection implications of Brexit today. So just to talk very briefly to set the scene on a few points before we start. So firstly, just to highlight that we do have extensive guidance on data protection and Brexit on the ICO's website. And there is also extensive guidance on the government's website, gov.uk as well. So it's always worth bearing in mind that that information is out there and available as well to help you. And in Margot James's speech just before me, she very much sort of neatly set out the position and the challenges ahead in terms of data protection and Brexit. So it is a challenge because of the importance of data flows in today's digital economy. So the data flows between the EU and the UK, and those data flows underpinning the growth of the digital economy and how public services need to exchange data in a modern world beyond the borders of the UK. And currently, as a member of the EU, data can flow freely without friction between the UK and the EU and vice versa. When we become a third country, things will change. So as Margot set out in her speech earlier, the UK intends to apply to the EU for an adequacy decision. If a deal, the withdrawal agreement, is agreed between the UK and the EU, that will allow for a transitional period or an implementation period to actually then put in place the adequacy decisions, hopefully by the end of 2020, looking at the timetable that had been set out. It's worth noting as well that that would be two adequacy decisions. It could be an adequacy decision under the GDPR, but also an adequacy decision for law enforcement data under the Law Enforcement Directive. As Margot set out, things become a lot sharper in a no-deal scenario, and I suspect it's the no-deal scenario that we'll particularly focus on in our panel today, because in a no-deal scenario, there would not be time to get that adequacy decision in place if we leave the EU in that sudden way. There wouldn't be time for that decision to come from the European Commission. So, over to the panel. and our first questions. So firstly, I'm going to turn to Mikko to really ask you to set out your perspective from the perspective of Vodafone, particularly about the practical steps you took in Vodafone once you heard about the impending nature of Brexit. And then was there anything as well you learned and you'd have done differently over the period of time that you've been planning for Brexit?
Thanks, Steve. Yeah, there's quite a few things that are relevant. So from a data protection point of view, the biggest challenge with Brexit really is that of the data flows between the EU and the UK and the other way around as well, as you rightly said. So if and as the UK becomes a third country, those data transfers will need to have a legal basis. There needs to be a compliance instrument that makes those data transfers lawful. Today, while UK is still a member, companies should at least have in place data protection agreements to cover the transfers of data between the group companies in a company like Vodafone and the flows between your various suppliers, even in a European context. Going forward, you need to add the element of international data transfers compliance to that. Adequacy, we know that would have been the ideal option, but due to reasons that were explored already earlier, we don't have that now. So something else needs to be put in place. Binding corporate rules were something that we would otherwise or kind of quite frequently actually explore if we should apply them. So far, we haven't. So that leads us with the standard contractual clauses. So we have a structure in place, as I mentioned, where all the data flows between our various entities, and I can tell you there are quite a few of them in the UK, in the EU, and globally are covered by data protection agreements. We also have a structure in place that ensures that we have the standard contractual clauses as part of the same contractual framework. And this is something we've actually had in place for a long time already. If we hadn't had that in place, I think this would have been a massively complex exercise. How do you know what data transfers you actually have in your company? Well, the GDPR program obviously prepares one for that. But the sheer volumes of agreements that you would have to put in place is quite staggering. So if you're starting now, I'd say double down with your efforts. But I guess those are the main elements of how we've been dealing with the data flows. So understand what data flows you actually have, so that you know what your problem actually is. Make sure that those are covered by instrument that makes the data transfers lawful. For us, obviously, that's been the standard contractual clauses. And I guess those are the main steps. Thanks.
Okay. Thank you, Mikko. And now going to turn to Roxanne, and obviously from that wider business perspective, can you tell us a little bit, Roxanne, about what you've learned about speaking to business over the last few years, about preparation for Brexit in terms of data protection? What's keeping businesses up at night? What are they concerned about?
Quite a lot of things. Thanks, Steve. It's really great to be here. For people that might not know, the CBI represents around 190,000 firms of all sizes. And throughout the Brexit process, data has consistently been one of the top issues that the businesses have talked to us about. And as we're reaching the culmination of the negotiations, there are a few issues that businesses are sort of always picking the phone up about. I think the first, of course, is no-deal planning. The big ask there has been for a centralised, focused piece of guidance that firms can look to, and wonderfully the ICO guidance does that and has made my job so much easier. But the other big aspect in the no-deal planning is, of course, what's happening on the EU side. And really sort of the comparison point that firms have brought up is, of course, when Safe Harbour went down, which was the US-EU agreement, there was an element of regulatory forbearance. So there wasn't a huge amount of enforcement activity. But in the discussions that we've had with the EU, they were very keen to stress that the same would not be applied in a no-deal Brexit scenario. So all the things that we're talking about today are very, very important, and we can't be relying on regulatory forbearance, which I think is very important and not a surprise. The second point I think worth mentioning is, of course, the importance of securing an adequacy decision before the transition period ends. The UK data economy is worth £240 billion, and an adequacy decision is essential for enabling that and supporting that economy. And the UK has an incredibly strong case for getting an adequacy decision. We will have an unprecedented amount of alignment by the time we leave the EU. And I think crucially, the issue of national security is something that's been raised by businesses quite a lot in terms of something that will come under consideration. And last year, the UN Special Rapporteur for Privacy actually gave the UK a really big thumbs up for our national security regime. So again, that will be a really important piece of evidence going into that decision. The third thing which I'd finish on in terms of what businesses have been talking to us about is with the parliamentary arithmetic the way that it is, and the fact that Theresa May and Jeremy Corbyn are now in direct negotiations, there is growing interest in what's Labour's position on digital policy, and we've had a lot of engagement with them, and we've met with the Shadow Digital Minister, Liam Byrne, and it was really pleasing to hear that they're totally on the same page with the government when it comes to getting an adequacy decision quickly and the importance of alignment. So that's really good that there's sort of cross-party support for this.
Okay, thank you, Roxanne. I'm now going to turn to Eleanor, and I know that you've got clients in the public sector as well as the private sector, Eleanor. So I know also you've worked in the public sector as well. Just so by way of opening as well, could you perhaps say something about particularly the challenges and issues you face with the clients from the public sector perspective as well? Because I know we've got lots of public sector DPOs in the audience here today as well.
Yes, of course. Yes, thank you very much, Steve, and good morning, everyone. It's lovely to be here and to participate in this very interesting discussion. I think the difficulty that everyone is facing, frankly, private and public sector, is the uncertainty. That on the one hand, if we do have the deal and we have the implementation period, data just continues to flow as normal, and there's nothing to worry about in that. But obviously, the other alternative, which everyone is keen to do as much as they can to prepare for, is the no-deal scenario. So I'm going to focus a little bit on, public sector and the no-deal scenario. And I think the message really is there isn't a huge difference, because everyone knows that they need to put something in place, and they're asking, when should I do that? And we'll go into a little bit more detail on that in a moment. But just by way of introductory remarks, really, it is about thinking about your data flows. Is their data flowing most crucially from the EEA to the UK? Do you know your supply chain? Do you know exactly how that's going to work in a no-deal situation? And putting something in place which will allow that to flow as it did before. And really, so there isn't that much difference, I think, between public and private sector in terms of that. But also, I think risk assessments are really important. So for public sector organisations in particular, I've got these particular functions that I need to carry out. Are those going to be endangered in any way if I'm not going to manage to get my transfer mechanism in place in time in a no-deal situation? And it really is quite difficult, I think, to navigate this territory because, as I say, on the one hand, we've got the possibility of not needing to put anything in place at the moment versus having to do all of that work. So where we are really is, saying to clients, look at the ICO website, it's terribly helpful on all of this, but also make sure that you know what your data is, that where it is, and what you would do in that no-deal scenario. And then risk assess, as I say, how crucial is it to my functions that this data flow continues? And in the most extreme scenario, I think there's a question about, is it better to onshore it? But I think the chances of that are quite low, and that in fact, if you have thought that through, you should be able to put something in place in order to mitigate any no-deal scenarios. So that's a bit by way of introductory remarks on that point. Mm-hmm.
Thank you very much, Eleanor. And just turning back to you, Mikko, can you say a little bit more about the risk assessment you undertook in Vodafone and where you really chose to sort of pinpoint your efforts, building on what you said earlier?
So I guess the Brexit preparations in many sense kind of morphed into our generic GDPR preparation. So we ran a very extensive exercise to really pin down the data processing activities that take place in the organization. So we defined, we found a list of actually kind of like all the processes that exist in the company, and we used that as the kind of framework to understand what kind of data processing actually takes place. We put those in priority order: high risk, medium risk, low risk systems and processes, and then we did a very extensive assessment approach to across the whole piece. So thousands of assessments actually across a very significant number of controls. And the existence of data protection agreements, existence of international data transfer mechanisms was one control that was tested in that massive exercise. So we very quickly then had the scope where these particular challenges needed some further work to assess. And I think that is, I would definitely recommend that as the best practice. Although it's, I think it's very laborsome, but I think many companies at the same time probably have never really done that. Mm-hmm. So in the everyday pressures, the privacy practitioners probably mostly deal with stuff that comes to their desk on a day-to-day basis. So please, I think it's a very good idea to try to carve out the time and space to really pin down what you're actually doing. And then you just apply normal, fairly standard enterprise risk management practices, actually. So you know that, well, in this particular processing activity, these are the gaps that you have. This is the business owner who needs to commit to these remedial actions, and then you keep them honest through means available in your organization.
Okay, thank you. And from what I'm picking up there as well is that the investment you made in your GDPR program and then using that to build and help with your Brexit preparation, but the two went hand in hand. So you didn't start from scratch with your Brexit program. Is that
That's
correct?
absolutely correct. And as I was preparing for this session, I was almost thinking that would it even be possible to go through your Brexit preparations without having done a proper GDPR implementation. Obviously, this depends on the type of organization, the size of the company, the processing activities, but at least in our case, I think the fact that the GDPR made us double down our efforts in really governing the data that we process was the main, kind of the building block for Brexit preparations. So obviously, the company like ourselves would have separate governance for privacy and for the various aspects of preparing for a possible no-deal scenario, but the activities on an operational level tend to morph very nicely.
Okay, thanks so much, Mikko. Turning back to you, Roxanne, can you say a little bit more about how you sort of assessed the risk in the landscape and particular areas of risk you've seen, perhaps with particular sectors as well, and how that might be approached?
Yeah, definitely. I think sort of when it comes to the no-deal scenario, I think the challenge for a lot of companies is there are over 40 no-deal technical notices, and in terms of prioritizing what needs to be done, that's a real challenge for firms that don't have a huge amount of policy and legal resource. And already mentioned the ICO guidance, but one of the things the CBI has done is we've actually pulled together sort of the top 10 no-deal issues and actually pulled together every single piece of guidance that's available on that. So, of course, it involves data, but it also has things around finance and access to talent, and very happy to share that. Yeah, so I think that's the main thing that we've done.
Okay, thank you. And turning back to you, Eleanor, in terms of assessing risk, what are some of the conversations you're getting with your clients where you suddenly see indicators of risk, or as well some myths building up as well in terms of flags you're thinking, I'm going to have a straight conversation with my client here about what they need to understand? Can you just say a little bit more about that process?
Yes. I mean, I think the difficulty to an extent has been actually identifying the risk in the first place with some organisations, as Mikko was saying, If you haven't entirely finished your GDPR readiness program and you haven't mapped all your data, you really need to sort of start off actually by doing that first before you can really make a proper assessment of risk. In a few examples, we've been slightly playing catch up and trying to look at those supply chains and understanding how they actually impact on core functions. But so once you've got to the stage of doing that mapping and knowing where you are in terms of risk, it's looking really at the big contracts, the ones that really mean that if you weren't able to transfer that particular set of data, you know, that's really going to have a significant impact. And trying to engage those companies, those suppliers, as soon as possible, because of course with a flow from the EEA to the UK, it is actually they who've got to put something in place in order to enable that transfer to happen. So it's sort of nudging them in that direction, perhaps pointing them to the EDPB guidance and saying, look, you know, there is some guidance on this, there is a regulatory risk for you here, we want to continue this business relationship, but have a look at that guidance, have a look at the ICO website. There are things we can do. Standard contractual clauses are not going to take a huge amount of time necessarily to put in place, but we do need to have those in place in order that that really important relationship can continue and that those data flows can continue safely post a no-deal Brexit.
Okay, thanks, Helen. So I'm getting quite an important thing there about to speak to the other organisations involved in your supply chain, but you must do that work now to identify those areas, even if you don't trigger a full action plan. Would that be right?
Absolutely.
Yeah.
Absolutely.
Okay. Thank you very much to the panel. I'd like to go out and see if we've got any questions from the floor now. So I think the roving microphones should be here. So have we got any hands? So I've got number 2 there. So lady at the back. Thank you.
Hello, thank you. So far, the European Data Protection, the European Board, has said that there would not be adequacy for the United Kingdom after Brexit if there is no deal. What would be the situation for an organization who have non-EU organization who have the representative in the UK? And what would be the situation of UK organization? And they operate in the rest of the EU? Would they need to have representative? And also, I guess they will have to find a new supervisory lead for their binding corporate rules.
Okay, thank you very much for that question. That's actually something we thought might come up on the panel today of another important dimension of the implications of Brexit in terms of who your lead supervisory authority will be within the European Union framework in future after Brexit. I know you've had some thoughts on this, Eleanor, and that's cropped up with your clients, hasn't it, actually?
Yes.
So are you happy to answer
yes,
that
absolutely,
question?
yes. So in terms first of the representative, you are absolutely right. So if you're EU representative, because you were caught by the extraterritorial provisions in the GDPR and you had your EU representative based in the UK, because in a no-deal Brexit situation, the GDPR no longer applies, although the standards apply and we turn the GDPR into the UK GDPR. In fact, the EU version, as it were, will not apply to the UK, so you will need to nominate, as you say, a representative within the EU in order to comply with those provisions in the GDPR. So that's what you'll need to do there. And in the same way, the lead supervisory authority, if there's a no-deal Brexit, then the UK's Information Commissioner will no longer be able to be the lead supervisory authority. And so you will need to look at your arrangements and see where, in fact, it may be best to have the lead within the EU's member states. So yes, there will be differences there and things that you need to consider.
Okay, thank you, Eleanor. Just looking at Mikko or Roxanne, do you want to add anything?
Yeah, well, maybe just to add that the appointment of the new lead authority is not just a formality, obviously. So there's a criteria that has to be met. So if applying that criteria, you find your lead authority today in UK, just because of Brexit, the factual analysis doesn't necessarily point to any other country. So I think that's something that companies should probably also consider. So there may be a possibility that a lead authority actually doesn't exist in the EU. You'd still have to appoint your representatives. There would still be consistency mechanisms, perhaps, or joint operations by the regulators in case that sort of an eventuality were to arise. But yeah, so look at the criteria and see where that takes you.
Okay, thanks, Mikko. Is there anything you want to add on that, Roxanne? No. Okay, are there any more questions? One to the side there. If you could say who you are and what organisation you're from as well, that would be great. Thank you.
Dan Davis from Leonardo. What are your thoughts on the following scenario, where you have a UK data controller who contracts with an EU data processor? They transfer data from the UK to the EU data processor, but the data processor can't transfer it back to the data controller because it's not a controller-to-controller relationship, so that special condition doesn't work, and it's not a controller-to-processor relationship, so that special condition doesn't work either. How do I do it?
Okay, thank you very much. I understood that question, but it is a gap which has been identified. I think it's come up with you and your clients, Eleanor. So are you happy to say a little bit on that at the moment?
It has come up, and there are various ways of tackling it that we've talked about, certainly within my firm. One of the common things is that people do want to show that they, if the regulator was to come knocking, that they have done something in this space. And so what can be done, although it's not a perfect solution, and by the way, this isn't a solution created by Brexit, this is a solution generally because there aren't the standard contractual clauses to deal with that particular scenario. So what some clients do is that they create this sort of legal fiction whereby essentially you're contracting as the controller with yourself. And so, you're using the controller-to-controller standard contractual clauses. Everyone knows they don't work, but at least you're showing that you have done something and you've created this legal fiction. Yes, it's not perfect, but it's at least something that you can show to a regulator should they come knocking. Others say, well, there's an argument that this isn't really a restricted transfer in the first place because the data's come from the controller to the processor and back again. And, so that's another argument you can think about. I think a lot of people they want some piece of paper to show that, yes, we thought about this, we've tried to put something in place. But there's no perfect solution at the moment.
Okay, thanks, Eleanor. So really the message there is, as well as making an attempt and demonstrating and documenting what governance you do have in place, given there's a gap in the framework for this situation at the moment, and probably it wasn't really envisioned when the law was drafted and everything hasn't caught up yet.
No, absolutely. Yes, absolutely. I agree with that.
That issue as well is currently being discussed in the European Data Protection Board as well. I'm going to a meeting in Brussels this week, and so there should be further guidance to come from the European Data Protection Board on that matter soon as well, but thanks for raising that one. Okay, I think I've got time for one more question before I finished. When I'm looking at my phone, I'm not checking the latest tweets from the BBC website, I'm checking the time. Any more questions? I can see. Oh, number two at the back there. Thank you.
Hello, my name's Leslie Holmes. I'm a DPO for MHR. Can I just turn the same question that we just had round the other way, where we are a processor for a European company and we process in the UK. So we are effectively transferring data from the EU to the UK and back again.
Okay, thank you very much. Eleanor, are you able to help with that?
Yes. So the way in which things work now with transfers from the UK to the EU are essentially going to continue even in a no-deal scenario. And that's because if you look at the EU exit regulations, which the government published a few weeks ago, we are deeming the EU to be adequate on a transitional basis. So you don't need to worry about the flow going from the UK to the EU. That shouldn't be a problem. Obviously, for entities in the EU, they are going to have to find some sort of mechanism by which to transfer the data back to you. But if it's a controller to processor situation, then that shouldn't be a problem. But any UK to EU data flows, you can continue those as before.
Okay, thank you very much, Eleanor. So just to sum up very quickly, I'm just going to give each panelist just 30 seconds to highlight again the key takeaways that organisations should be thinking about in terms of planning for data protection and Brexit before we wrap up. So I'll start with you, Mikko. What are the key takeaways you want everybody to be reminded of from this panel?
So get very familiar with your data flows, both within your corporate group and with your suppliers. Make sure that you have the right structures in place, and I would think that for many of us that's the standard contractual clauses. Pay attention to the Schrems case. Who knows if the standard contractual clauses will continue to be valid as they are? I think they'll probably will, if the court finds itself, proposing some adjustments, probably the instrument itself still continues to be valid, but some changes may be needed. And and consider the lead authority concept as well.
Okay, thank you, Mikko. And your key takeaways, Roxanne?
My key takeaways. So I think the first would just be on no-deal planning. Obviously, there's a huge amount to do. Data is one aspect. If you want further resource and advice, CBI does have that completely free of charge on all the no-deal issues. Second would be also to pay attention to the other EU data regulations that are happening right now. So e-privacy. The received wisdom was that the UK would be adopting the regulation, but it would be out of scope for an adequacy decision. But because of the delays in the Brexit process, e-privacy is definitely one to watch in terms of the UK's adoption of that. And then the third sort of final point would be to keep banging the drum for the ICO, because having the ICO's presence in European regulatory fora is incredibly important. It's something that businesses talk to us about every day, and I think it's really important that when we're speaking internationally on this, that we continue to push for the ICO to have a continued role in Europe.
Okay, thank you, Roxanne. And Eleanor?
Yes. Well, the main message is don't panic. It's normally going to be possible to solve it. You just need to make sure that you really understand your data flows, as Mikko was saying, that you can put something in place. It shouldn't be too difficult to do that. I mean, the ICO website has a lot of help on setting, putting in place standard contractual clauses and that sort of thing. So it's not insoluble, but don't just brush it under the carpet. You do need to do something, and you do need to be ready to ensure that those really important functions or contracts or whatever can continue post a no-deal Brexit.
Okay, thank you, Eleanor. So we'll finish there. So key messages about mapping your data flows, understanding where the risks are, building on your GDPR practices as well in terms of looking ahead for those future challenges. So I'd like to really thank my panel today, because it is quite a big ask actually to come up here to speak about a topic which is so uncertain at the moment, and it's been really fantastic to have their expertise up here today. So thank you for the panel.
Thank you.